Hello everyone. From our last few videos that I have been discussing criminal law. So today in this video I will discuss criminal procedure code. Okay. So let's begin with the meaning and concept of criminal procedure code. So what does it mean? Criminal procedure code or simply CrPC is the body of rules that defines the criminal proceedings, court trial, and police investigations, procedures and methods. Okay, so its object is to provide a mechanism for the investigation and trial of offenders. As we have already stated that criminal procedure code is a procedural law. So it is talking about the procedure, isn't it? So this is the major purpose, object, meaning of criminal procedure code or simply CrPC. Now let's check out the classification of offenses that defined under the criminal procedure code. The first one is bailable offense. It is the minor offense in which the punishment is less than 2 years. Since it is non-serious type of crime, therefore it is matter of right of the accused to get the bail while the trial is pending. For example, wearing soldier's garb, sailor, airman, defined under section 140 of Indian Penal Code, that is bailable offense. Some examples of bailable offense are punishment of unlawful assembly, section 144, furnishing false information, section 177 of IPC, false statement on oath to public servants, section 181, threat of injury to public servant, section 189, giving false evidence, section 191, threatening person to give false evidence, section 195A. So there are so many that come under the bailable offense. Okay, the next one is non-bailable offense. Non-bailable offenses are those offenses which are serious in nature and bail is a privilege and only the judicial magistrate can grant it. In bailable offense, a police officer can also, but in non-bailable offense, only judicial magistrate can grant it. Hence, the arrested person cannot demand bail as matter of right. Pay attention. He can get bail or cannot, as he cannot demand it as the matter of right. So this is the basic difference between bailable offense and non-bailable offense. Examples of non-bailable offense are murder, section 302 of Indian Penal Code, dowry death, section 304B of Indian Penal Code, attempt to murder, section 307, voluntary causing grievous hurt, section 326, kidnapping 363, rape 376, etc. All these offenses are covered under the non-bailable offense. Next one is cognizable offenses. Some offenses are such serious in nature that for such offenses, police officer has given the power to start the investigation and arrest the accused even without any warrant. Pay attention. In respect of cognizable offenses, police has the power to start investigation to arrest accused without warrant. For example, murder, rape, etc. Next one is non-cognizable offenses. Some offenses are such non-serious in nature that for such offenses, police officer needs to wait for warrant to start the investigation and arrest the person. For example, case of criminal defamation. Next one is compoundable offenses. Some non-serious offences are of such type that the state which conducts the prosecution and the accused can come to an arrangement where, instead of being imprisoned or punished, the accused can pay a fine. Okay? In other words, the complainant, one who has filed the case, that is the victim basically, willingly may enter into a compromise and agrees to retreat and drop the charges against the accused. But you need to pay attention here. That is, however, such a compromise should be a bona fide and not for any consideration to which the complainant is not entitled to. So it has to be under the law itself. It's not something beyond the purview of law. As per the section 320 of CrPC, it is of two types. So that is the compoundable offense is of two types. The first one is court permission is not required before compounding. For example, adultery, causing hurt, defamation, criminal trespass, etc. These are such kind of offences for which compromise is possible without the permission of court. Or in other words, for such offences, court permission is not required to compromise, to compound, okay? But in the second category, court permission is required before compounding. For example, theft, criminal breach of trust, voluntarily causing grievous hurt, assault on a woman with intention to outrage her modesty, etc. So these are of course the minor crimes, but for this to resolve it or to compromise, court permission is essentially required. And the last one is non-compoundable offense. Some offenses are such serious in nature that cannot be compounded. In such offenses, compromise is not allowed. So only prosecution is allowed, okay, in such kind of offenses, such as murder, rape, etc. Now, the next point of our topic is stages in the prosecution of an offense. So, it means that when prosecution of a person or accused starts, so what are the stages? So, that we will discuss in this topic. Okay, so primarily there are two stages. The first one is the police investigation. Okay, when police officer registers a complaint normally made by a victim or his or her relatives, then police makes investigation based on the written complaint and submit the charge sheet. Okay, and then the second stage starts, that is prosecution by the state. Based on the police report, a state initiates the prosecution process against the accused. In such a criminal trial, either the accused convicted, found guilty, or acquitted, found not guilty. However, here I would like to add one more point, that is, as per the CrPC, there are three stages of criminal justice system. Okay, the first one is investigation. Okay, what happens here that once the FIR is registered, respective police officers are required to initiate the investigation process. So an investigation is conducted by a person authorized by the magistrate, normally police officer, as all of you know. After investigation, the second stage comes, that is inquiry. Inquiry refers to the proceedings conducted by a judicial magistrate. So an inquiry primarily aims at determining the truth of reported crime or falsity of facts, if any. Okay, so now you need to understand the difference between investigation and inquiry. I believe some of you might know the differences between investigation and inquiry. Okay, some of you might not. So investigation is the process to find the facts and evidence against the accused based on the complaint. Okay, and it is done by the police. But inquiry is the kind of investigation that is done by or conducted by judicial magistrate. Investigation is the primary process, the first process or mechanism. Okay, however, inquiry is being done after the investigation if such need arises. Okay, as you know that investigation is done by police, but inquiry is conducted by judicial magistrate. Okay, and the last one is trial. It is a judicial proceeding where relevant evidences are allowed to be proved or disproved, and based on that the guilty of a person is adjudged, and hence an acquittal, that is an exoneration from the charge, or a conviction is decided. I believe you got it. Means after the trial, if everything is done, there are two possibilities. Either the accused will be acquitted if found not guilty, and convicted in case if found guilty. Okay, now we will check the steps that is done by police investigation. Once the FIR, of course, that is the first information report, is registered, then, and yes, if it is a cognizable offense, in that case, then police starts its investigation. Okay, what happens in police investigation? What are the major steps? I mean, the first one is police begins the investigation process by visiting the crime spot. Okay, so police begins the investigation by visiting the crime spot, and after going there, what he does there? Collecting the facts, evidence. Okay, he also tries to collect the information covered by some CCTV and something like that sort of thing. So he tries all the things through which he can collect the evidence. Okay, after that, the next step is discovery and arrest of the suspected offender. So if he found something concrete or something that made him believe that he is the accused and he has certain amount of proof against him, then what he can do? He can arrest that suspected offender. Okay, after that, the next step is collecting the statements of witnesses or witness, and the next one is may be required or may not be, that is scientific analysis or taking expert opinion for what the document or whatever the things police collected. So verification of all those documents, the statements, the evidence, everything is required in order to prove the crime, isn't it? Okay, so once all these steps are followed, then police prepares a charge sheet. Okay, and what charge sheet is? It is the detailed report of the crime and subsequent investigation that he did. Okay, and then after the preparation, he submits to the judicial magistrate. Okay, so this is what and this is how police investigation is normally done. Okay, So this is the major steps that need to be followed by police officer while doing the investigation. Okay, but here I would like to take your attention, that is, in case if a police officer refuses to register the FIR and investigate an offense, what will you do? Now you have two choices. The first one is either you can go to the senior police officer, maybe the superintendent of police, or you can directly file a complaint to the magistrate. Okay, so you have two options. In case police officer doesn't register your FIR or refuses to investigate. Okay, so this is all for this video. I believe you must understood the meaning and the purpose of CrPC, that is Criminal Procedure Code, and the types of offenses and the process of police investigation. In next video, I will discuss trial process. So how the offenses or offender being tried in the court, we will discuss in detail. In the meantime, go back and watch it again so that you could have the concrete and substantial understanding of this topic. Okay, so see you in next video.